Office of the Court Administrator versus LADAGA. Administrative matter number P-99-1287. The decision date is January 26, 2001. The case is about a court clerk being reprimanded for acting as a pro bono counsel for his cousin without obtaining written permission from the court, although his action did not constitute the private practice of law. Let's start the facts of the case. Attorney Misael M. Ladaga served as the branch clerk of court at the RTC Branch 133, Makati City. On August 31st, 1998, Ladaga requested permission from Court Administrator Justice Alfredo L. Benipayo to act as pro bono counsel for his own cousin, Narcisa Naldoza Ladaga. In a falsification of public document case at the MTC Quezon City Branch 40. Before receiving a response, Ladaga appeared in court and Lisa Payoyo Andres, the private complainant, questioned his authority to do so. Ladaga admitted his court appearances without prior authorization, citing humanitarian reasons and his cousin's financial incapacity. He submitted leave applications for the court dates he attended. On December 8, 1998, the court denied his request and instructed the office of the court administrator to file formal charges against him for violating the Section 7B paragraph 2 of the Republic Act 6713. An administrative complaint was filed on January 25, 1999. Ladaga defended his action based on his close familial relationship and intent to provide free legal assistance. Judge Josefina Guevara Salonga recommended that Ladaga be reprimanded with a stern warning. The Supreme Court concurred with his recommendation. The issues of the case are, first, did attorney Misael M. Ladaga engage in private practice of law by appearing as pro bono counsel for his cousin without prior permission from the court? And the other issue is, did Ladaga violate the requirement to obtain written permission from the head of the department before engaging in private business, vocation, or profession? The rulings of the Supreme Court here for the first issue is the court ruled that Ladaga isolated court appearances did not constitute the private practice of law as defined by law. And the ruling of the Supreme Court for the second case is the court found that Ladaga violated the requirement to obtain written permission from the head of the department, which is the Supreme Court, not merely presiding the judge of the court. And the rationale of the case was the court clarified that private practice of law under Section 7B, Paragraph 2 of the Code of Conduct and Ethical Standards for Public Officials and Employees and Section 35, Rule 138 of the Revised Rules of Court refers to a succession of facts of the same nature, habitually or customarily offering oneself to the public as a lawyer. Ladaga's isolated appearances as a pro bono counsel for his cousin did not constitute private practice. However, Ladaga failed to obtain the necessary written permission from the head of the department as required by the Section 12 of Rule 18 of the Revised Civil Service Rules. The presiding judge of his court was not the appropriate authority to grant such permission. Thank you.